Good morning, Mr. Murray.
Good morning, Madam Chief Justice. May it please the Court, my name is Lawrence Murray. I represent Mr. Doe on an appeal from a 30A decision of the Superior Court. I think that I assume the Court is familiar with the facts, but I think a brief recitation of some of the more material facts may be helpful in providing context to this case. Mr. Doe was 20 years old at the time he offered a plea of guilty to the crime of rape in 1979.
Does it show how old the victim was?
It does not in the record, Your Honor. We know it was at least an adult because it was not a rape of a child.
No. Yeah, I figured that out. Well, the facts are pretty straightforward. I mean, he was 20 years old. He's gone. He's subject to the act because of a 5-week window that he fell into, and here we are 22 odd years later, and the statute's mandatory. So why do you say he should not, if the statute's mandatory? Is the statute unconstitutional? What do you do for him?
I am arguing to the Court that as applied to Mr. Doe, that the denial of him of any opportunity to present evidence or to have evidence presented that he does not represent any threat at all to either vulnerable persons or children who are the protected class under this statute violates his due process rights as applied to him.
Federal?
My focus is on the mass declaration rights, Your Honor.
Isn't it true? Is the federal question pretty much been decided against you in the Connecticut case?
I would say that that is the precedent that is there. Yes, Mr. Justice Cordy.
Is this the question that you're raising here? Is it the one that the Court didn't answer in the 2006 John Doe case?
1211.
Yeah.
Yes, Your Honor. Yes, Your Honor. And in fact, the appeals court had asked us to brief separately that issue after this Court's decision. And I'd say this is exactly that case.
So the federals have decided this against you, and now we've got to look at the state constitution and decide whether a due process is violated in this kind of case.
Yes, Your Honor. And I think it's instructive. Well, in the first instance, I hope it's late in the day at this point for the argument to this Court that the registration imposed on a level 1 offender doesn't implicate any liberty interests. I think that it is well established in the Court
Now, when
decisions.
you say if we decide he should have an opportunity to present more information, material, so on, I take it this would be some kind of expert testimony because he did present, or they knew, that he had gone 22 years with no offense. It's in the findings or the decision that he's been married, he's got a very stable environment, a lot of support, et cetera, et cetera, et cetera, completed his probation successfully. So what are you talking about, expert testimony? What?
Well, Your Honor, I don't think it necessarily involves expert testimony. I guess if we focus on the hearing officer's decision here, he has no discretion. What distinguishes this case?
True.
He certainly says he doesn't.
Yeah.
Well, is it constitutionally sufficient that the statute differentiates among offenses rather than among people?
I would say not, Your Honor, because the requirement, when we're talking about a liberty interest at stake here, the requirement is that they be narrowly tailored to protect an interest.
Is there any legislative history here? I mean, why did the legislature put this in? Did they rely on studies that people who commit rapes and things are never, quote, cured? Or did they just borrow from another state? Has anybody looked at this?
Well, you raise an interesting point, Your Honor, because that issue was addressed in Doe 1211, that there was a lot of evidence presented that, in that case, pedophiles can't be cured.
Well, that's pedophiles.
Yes, and that persons, in this case, Your Honor, there's absolutely no evidence that was presented to the board.
Yeah.
There's just a blanket statement that someone who committed a rape, and I don't mean in any way to take away from the seriousness of that charge.
No, I don't mean
at
the
time.
board. I'm talking the legislature.
There is no evidence that has been presented to this Court, and there's no evidence in the record that I'm aware of.
Has anybody looked at legislative history on this point?
I was not aware. I was not able to find any history on this point.
So you did look?
I did look, Your Honor. I wasn't able to find any history on that point, on the charge of rape.
Was there some evidence that you tried to get in at the administrative hearing and were prevented from offering?
I was not, yes. Well, let me answer your question this way, Justice Spina. The decision by the board was that the only issue that we could present was whether or not he was convicted of that rape. And more importantly, we did present evidence showing, and the court has made reference to that, of the citizen he's become, of the role model he's become, and everything else. But the hearing officer said, I have no discretion. He can't consider any of that evidence.
But was there, did you offer an affidavit or make an offer of proof? Was there something on the, is there something in the record that indicates that the hearing officer would not let you offer evidence by a particular, offer testimony by a particular witness or present affidavits, anything like that?
No, Your Honor.
So you got in all the evidence you wanted to get in. The question is whether or not you were allowed to argue certain things.
But
Well,
wasn't it the case that before you even had the hearing, that the rule was all you can do is show that you weren't the person that was convicted on this day?
Exactly. There was no hearing. There was no opportunity for a hearing. There was no opportunity to persuade this hearing officer that he does not represent a threat. And he relies, and reading the statute as it's written now, saying that he has no discretion. In fact, he said he's not unaware of the compelling inequities. It says equities, but I think he really means inequities of this situation. But since the Superior Court has no discretion, surely he has none as
So
well.
he's got to register for the rest of his life.
Yes, Your Honor.
But registering only means that he has to, once a year, give his address, right? I mean, it's not, the information is not passed out to the public in any way, is it?
For a level 1 offender, it is not, Your Honor. But I say that, and I refer back to Justice Freed's position, where what we're talking about here is not simply the ministerial act of doing this, but a fundamental change in the relationship of this citizen to the state. Prior to this act, there was no ability of the state to require the whereabouts of an individual like this. It's more than just requiring information, Your Honor, because first of all, the record of conviction is there, but they're labeling him, and Justice Cowan had made reference to this in the Roe decision. It's a statutory branding of this individual, Your Honor. It's a regulation of the person themselves. And prior to that, the state had no right to demand that of persons. And it suggests that it's hardly innocuous to this individual. And this person can put a face on that, Your Honor. This is someone who resides in the community for 22 years. And every year, there's no evidence that he represents any type of threat to the type of people that this act was specifically designed to protect.
Except by definition, rape is a crime of violence, a sexual assault, right?
It is the conviction alone, Your Honor. That is correct. But, Your Honor, to that point, the state may have a compelling argument to this court that at least initially it has an interest in finding out who this person is who is convicted of a charge of a violent offense and identifying that person. But it's not a fixed interest. It's not static in time. And as more time goes on, 22 years in this case, and there is no evidence, and as alluded to earlier, there was no record evidence that someone who had committed a crime of rape necessarily represents a threat for the rest of their life.
But isn't that a legislative fact? Hasn't that been determined by the legislature, that somebody who's been convicted of the crime of rape, the elements of which include force or violence, or threat of force or violence, that's already been determined, and that is enough to satisfy the requirements of due process. This person constitutes a threat for the rest of his life, according to the legislature.
But I think it's this court's province to draw the line and decide if the due process alone, the legislative enactment alone, is enough.
What if we in effect rewrote the statute and said, okay, you got a point, there is some serious due process problem here. Someone who's classified as a level 1, without specifically talking about this man, will have to register for 5 or 10 years, at which point he may apply to avoid further registration. Would that cure the situation for you?
But doesn't that sound a lot like a policy judgment that the legislature should make, just changing it from lifetime to 5 or 10 years?
That's why I wouldn't presume to make that line. I think that is a legislative decision. I think we're faced with the question of, is lifetime with a lifetime registration requirement.
Well, the
that this-
the question really is whether it would, if you say it's unconstitutional as it currently exists.
Yeah, sure.
And I think Justice Graney's question sort of went to the, well, if it wasn't lifetime, if it was a 5-year minimum registration period after which your client would have the opportunity to demonstrate risk, would that make the statute constitutional in your view?
I think it comes closer to getting to the issue here, and that is the weighing of this liberty interest, which I'm assuming has been established, and the state's interest. Right now, as it stands, Justice Cordy, he has a lifetime requirement, even though there's no evidence, or I'm saying that the evidence is not there to support the idea rationally that this person represents any threat to these populations.
If the defendant...
I take it that in any event, you would say if the statute required 5 years, 10, your client has satisfied that because presumably the 5 or 10 years runs not from the date of legislation. It does today, perhaps, but from the release of incarceration and out in the community or the end of parole, whatever that period is, and your client has gone 2 decades.
That's correct, Your Honor. And I think it's significant. The passage of time has been specifically cited as this case, as an issue to consider in whether or not the due process has been followed. And if I might just follow that point. The statute in 1996 actually provided, after 20 years, that someone is relieved of that.
Yeah.
And in reacting to Wetterling and Doe 5, the legislature took that away from persons in Mr. Doe's situation.
Right.
Without comment.
Speaking of Wetterling, is it your view that if, in fact, lifetime registration was not required for persons convicted of rape, that our statute would then be in violation of Wetterling, which would mean that we wouldn't get federal funds in connection with various programs?
Well, I'm loath to say that we should be deciding this case based on federal funds. But in answer to your question, Justice Corey, first of all, our statute is retroactive, and as applied to my client. This statute is broadly retroactive.
Mm-hmm.
The Wetterling Act doesn't require that of the legislatures. It says that you may do this prospectively from that point forward.
So is it your position that due process requires a defendant be given the opportunity to show, regardless of the number of years the legislature may set, whether it's lifetime, 15 years, 10 years, that due process requires that a defendant be given the opportunity to show that he is no longer a risk to reoffend?
Your Honor, I think that has to be an issue. I mean, this court has decided that before someone can be compelled to pre-classification registration, that there has to be some showing that they represent a threat. Now, the charge itself, in an immediate sense, may represent some evidence of that. And then, therefore, it may not be beyond the legislature constitutional due process and to legislate that, at least for a period of time, someone who has been convicted of certain crimes needs to register.
We don't know anything about the facts of this rape, do we?
There was nothing presented by
he
the...
pled guilty, and I think in those days, even the DA had to give a summary of the evidence on a guilty plea. That's not in the record.
No, Your Honor.
So we don't know if it was, I don't want to say one kind of rape, or whether he, picked up someone off the street, almost. Well, that would be a kidnapping. Really violent rape. We just don't know.
Well, he got probation on the rape.
He got probation, so for 2 years. That's some indication, clearly, at least how the court viewed.
Well, it could be an indication that the so-called victim didn't want to testify against him.
No.
Well, in this case, Your Honor, I'm not sure if the record shows this, but there were co-defendants who were convicted and went to jail. So, but I don't want to go beyond that.
But that's in the record?
It is not, Your Honor.
It is not?
It is not in the record. The only thing in the record that was presented by the board is that my client was convicted of rape in 1977.
And that he got probation.
And then he got probation for 2 years and 5 weeks before this.
Okay.
Just to sum up, I just think that this is a case where we don't have to speculate about someone's dangerousness. He represents squarely to this court someone who has demonstrated that they do not represent a threat, nor a risk of recidivism. And all we're asking for, and I think the due process requires the opportunity to present that evidence to the board and have that board have the discretion to decide that issue.
But you wouldn't disagree that the board could find, even in these facts, I mean, you could challenge it, but the board would have the discretion to say, even though all that's true based on this evidence, we still think he needs to register.
Based on the conviction alone, Your Honor?
No. I'm saying if you got the hearing.
You
In
got
other
a
words,
hearing, but in this case, the only evidence that was presented to the...
No, I understand that. I'm just saying the relief you're looking for, you could get a hearing and still end up with a requirement that he continue to register after the hearing. But you're saying you can't conclusively presume.
Yes, Your Honor. Although I would say that here, the board presented all the evidence that it had.
No, maybe not. They might bring an expert in that says, you know.
But did the defendant present all the evidence that he could have presented? Did he present evidence about the circumstances of the rape that might indicate that, he was really not culpable or minimally culpable?
Well, Your Honor, no. What he did present some evidence, but once the hearing officer made it perfectly clear that they weren't going to grant us a hearing.
But don't you still have an obligation to make an offer of proof?
Well, the only basis for this was the conviction itself, Your Honor. In other words, the hearing officer, because they didn't feel they had any discretion, ruled as a matter of law, I suppose, that the only issue that I'm going to entertain from you is whether or not you've been convicted.
But this is an as-applied challenge, right?
Yes, Your Honor.
I mean, could we infer that in the absence of evidence by the defendant concerning the circumstances of the rape that this was done at knife point?
No, I don't think that would be fair, Your Honor. I think we have to look at what was presented in this, a conviction in which he was given 2 years probation 22 years ago.
Okay.
And that's the only evidence they presented on that. Thank you.
Thank you, Mr. Murphy. Mr. Less?
Madam Chief Justice,
Morning.
and may it please the Court, good morning. My name is Dan Less. I'm a Special Assistant Attorney General.
Can I start by asking you the same question? Are you aware of any legislative history on why this provision was put in?
No, Your Honor, I'm not. I think the closest that we get is the Wetterling relationship, and that the statute refers, when it was amended in 1999, there's multiple references to the Wetterling Act. And the Wetterling Act does define, as I cite in my brief, reference to the federal statute for sexual abuse, aggravated sexual abuse, which when you then parse it down through the Department of Justice regulations defining the implementation, and then you get to the statutes, you get rape falling within that scope of.
So somebody studied Wetterling, obviously, because it leads to the disbursement of federal money, and traced it all the way down like you're talking about, and said, oh, gee whiz, we better change this.
Correct.
And make this lifetime.
Correct. And I think.
I thought...
Okay.
I think that's.
Wetterling doesn't require that there be legislation on the basis of a sexual offense alone, correct?
Wetterling?
Yeah.
Yeah. No, I believe it does, Your Honor. You have to. If there's a conviction for a sexual offense, at a minimum, there has to be registration that then goes on to other requirements in terms of notification, public notification. But if there is a conviction for a sex offense, and then particularly with the definition of aggravated sexual abuse, the Wetterling specifically says that the duration of the registration period is for life.
Does Wetterling say that that's a conclusive presumption? I mean,
No,
you could have a hearing and still comply with Wetterling.
We could, but in this case, a hearing would be superfluous, because the statute says you as the board, you do not have the authority to relieve this individual. Therefore, at the recommendation phase, the board looked at all of the factors that counsel and plaintiff has put forward here and said, well, that's great. We're going to go as low as we can go, which is level 1. I want a hearing. A hearing isn't going to accomplish anything, because my hands are tied. I can't do anything unless you produce evidence that you're not the person who convicted this crime, or the conviction was overturned, or was somehow invalidated by the court since then, and he was given that opportunity and conceded, no, that's me, but I still
Yeah.
want to present.
So the only thing that, I mean, from his perspective under Wetterling, the only room here is, I mean, what our statute does that Wetterling doesn't require is, when it was passed, to go back all the way to August of 81.
It does, and I think that that's a fair reading of some of the differences. But I would also point out that if you read the federal regulations in terms of when does this apply, I mean, it's given the states are given considerable discretion, and assessments are encouraged to look beyond just the date of conviction. Although that was not a set requirement in the statute, and many states, the states are sort of split amongst the jurisdictions as to how far they do go back. Massachusetts elected to go back to, as it did in the 96 statute, to go back to the August 1st.
Are you aware of any other cases where state courts have been asked under their constitutions to do what we're being asked to do today?
My research did not reveal any similar situation.
One way or the other?
One way or the other.
Do you think we'll lose Wetterling money if we rule for the plaintiff?
That I can't. It would be something that would possibly become an issue that we would.
Well, let me ask the question slightly differently. If we based it on the fact that of the scope of the retroactive application, and not because Wetterling doesn't give that wiggle room, but in fact, if Massachusetts had chosen to go back only as far as 1990, this Mr. Doe would not be required to register. We wouldn't lose federal funds, correct?
I can't speak for the Department of Justice and what they would say.
But there's nothing on the face of it that says.
Well, I mean, I'm sure if this court were to rule in that way, we would try to continue to argue that we're still entitled to our federal funds, but I don't think we would.
There's nothing that says. I mean, going forward, we obviously have to comply with Wetterling.
Correct.
Wetterling doesn't require a retroactive application.
I don't believe that it does.
Mr. Les, let me ask you this, and I don't want to presume anything here, but it was not unknown before the sexual offender legislation scheme of statutes, federal and state, came into play, that in discussions for plea bargaining, a non-incarceration, 2-year probation of an admittedly serious charge might have seemed to be worth accepting the plea, even if one thought there were legitimate defenses, because, as always, you have to go to a jury and so on and so forth. And it seems to me that at least today, if one is a lawyer advising a client, you would have to say you will have 2 years of probation, but then you will automatically have irrebuttable lifetime, and that may change the plea negotiations, or the decision, not the negotiations, but the decision of somebody to plea, as opposed to saying, I really didn't participate, or I was a bystander, or whatever the defense is. It wasn't rape. To what extent do we take that into account?
I don't think it should be taken into account at all. I think the question is, did he get the due process that he was entitled to receive in making the plea in the first place? I mean, regardless of what the imposition of the punishment was, I mean, there are still serious ramifications for a plea of guilty, and 2 years of probation is still serious. He faces violation. He could face forever incarceration. There are implications way beyond, as this court and appellate courts have recognized, that result from a guilty plea that are beyond the control. I don't think that the mere fact of what the difference in what incarceration would be today versus 22 or 20 years ago changes the analysis. I think what's the critical thing is in this analysis is, did he get the was the conviction valid? And there's been no allegation by plaintiff that the conviction was invalid. He's made no attempt to seek to have the conviction overturned, saying based either on ineffective assistance of counsel or I got poor advice, or I didn't get a proper plea colloquy.
I wonder what would happen if he filed a motion to withdraw the guilty plea, and the DA assented. And the judge says, okay, based on what I see here, withdrawn.
He wouldn't, if that did
The DA
happen,
says, end of case, I'm not going to re-prosecute.
and if that happened, he wouldn't have to, and if we were told that, he wouldn't have to register, because he would no longer have a conviction. And that is something,
If
and
we
that is
uphold
something,
this, some defendants are going to start doing that.
they're doing it now. There are.
But that's very
That's a
difficult
real end
because,
run.
because there's probably no record of the guilty plea, and probably the judge is long since retired. It's almost impossible to reconstruct at this point.
I do know that.
But could I ask you to address, we seem to have gotten someone afield, what, the statute says what it says. What is your argument as to why it's constitutional?
Well, I think that this court held in Doe 1211, first of all, that on, at least facially, sexually violent offenses, and granted it was as to
Pedophilia.
as to child victims, was facially valid. I think that analysis that the court used in 1211 is just as valid in this case.
Why?
Well, because of the very nature of what rape is. I mean, rape is.
But we also know that the specific point of the statute is for children and other vulnerable persons.
And I think women who could be raped are vulnerable people.
And men who are raped?
And men, anybody who is.
That's my point. Then we're not talking about children and vulnerable persons. We're talking about anybody. So you have to read out the purpose of the statute is children or vulnerable people. You have to say the purpose of the statute is everybody.
Exactly, and I think that's what the legislature.
I don't think that is. I think the
And
legislature.
I think if you in
Can I
Doe-
just finish? I think
Oh,
the
I'm sorry.
legislature is very clear as to what the purpose of the statute is to protect children and other vulnerable people. And unless you say everybody is vulnerable,
it's
you're reading out of the statute what the legislature has in fact said is the purpose.
Well, I think. I mean, maybe we're saying we might be on the same page here, but I think if you look at this case, and just getting back to the facts, I mean, there isn't a lot about the facts of this case, but there is one thing that plaintiff indicates in the record in his submission to the board. He said the relationship that I had with the victim, and he actually says. It was on. I'm sorry. Oh, he said it appears on page 78 of the record. He said, I had no relationship with, quote unquote, the victim in my case. The entire incident was chance, fateful, terribly unfortunate collection of circumstances, heavily influenced by alcohol, again, taking place in an extremely youthful period in my life. This is a person, apparently, he didn't know. So to answer your question, Your Honor, I think anybody could be vulnerable. And I'm not saying, again, the board didn't make this man public enemy number one. He's not a level 3 offender. But it appears to be a stranger victim. This is exactly a vulnerable member of the population, somebody who he didn't know, and we don't know. Again, there was a kidnapping involved because he did plead guilty to a plea of count of kidnapping on this as well. But I think that there is, given what we know about that at least, and at least as it applies to this individual, it is a person who there is a vulnerability to just about anybody, so long as you're apparently, in particular, maybe even if alcohol is involved. So
Was he originally charged with aggravated rape?
He might have been. He might have been. I don't.
It's not in the record.
I'd have to go back and check the record. I don't recall that, but he may very well have been.
Mr. Les, let me, while you're looking for that, as you know, there were 3 justices of this court who concluded, and very specifically with the 4th concurring, that before a hearing, you could have legislation before a hearing where there's a grave threat to children, the risk of reoffense is compelling, but if there's no threat to children or other vulnerable persons, especially where the statute is retroactive, there were some concerns. That was before a hearing.
Correct.
Here, you have a hearing, but it seems to me if if the hearing has conclusively presumptive that the only thing you can contest is whether or not you were the person named, in the conviction. In other words, there's nothing about the threat to children is compelling, or there's no threat to children as far as we know, or other vulnerable persons, unless you take the whole world. Because why a stranger should make them more vulnerable than a spouse is not clear to me, but that's different.
Okay.
What is the difference between before a hearing or after a hearing where you can't produce any evidence?
Well, again, I think it relates to the legislative facts that the legislature makes, and it's a big difference in terms of what the legislature did in the 1996 Act and versus what the legislature did in the 1999 Act.
Why?
Well, what this court was concerned about in the Doe cases in the late 90s was, under the old statute was, all of the statutes were sort of put in the same pot. We're all sort of considered equally, and that a person, essentially a juvenile who, two juveniles who engage in consensual sexual intercourse are technically guilty of the crime of rape and abuse of a child, and they would have to register, where clearly that they would not, given the depth and breadth of the crime of rape and abuse of a child, these are individuals who would not don't pose any future risk or dangerousness. Same thing with an indecent assault and battery on a person over the age of 14. Broad range of behavior, from minor touchings to could potentially violent, aggressive touching. What the legislature did after learning from this court's teachings in Doe 3 and 5 is looked at this and they said, all right, segregating these out, we got sexually violent offenses. We have offenses that are serious, violent, aggressive offenses. These are people who, by the nature and essence of the crimes themselves, are always going to present some degree of risk. Not necessarily a level 3 risk, but some degree of risk. They're not going to get right down to that absolutely no risk, because they don't have, it involves physical violence and lack of consent.
Does the 1999 statute use the term children or other vulnerable persons?
It does not. In the 1996 statute, didn't either. Yeah. And I think that, again, it gets to how the legislature parsed this out, and I think they carefully crafted this statute narrowly to balance the public interest of maintaining information about people who have committed the most serious, egregious sexual offenses that are part of our criminal law, and providing a route of relief and elimination for offenders who aren't going to present that risk, or are possible of showing that they present absolutely no risk. And I think that was a fair and balanced, particularly given what an offender has to face who's a level 1, which is mailing in a form once a year that many of us do in any number of different types of circumstances, be it our taxes, be it registration of motor vehicles, what have you. It's not an onerous burden on his part. He's not being publicly branded. And I think it was a fair and reasonable and just balance that the legislature took based on the teachings of this court. It took it to heart and crafted a carefully calibrated, narrowly tailored scheme that bears a reasonable, rational relationship to a legitimate state interest.
Thank you, Mr. Less.
Thank you.
It was just rape, not aggravated.
I'm sorry?
The record says it was just rape.
Thank you, Your Honor. Thank you for clarifying that. I appreciate that.